Hello everyone. A very good evening to all of you. Welcome to the Officer Atta 24/7, the special session of your BRBL subject in the English medium language, in which I have just put some questions of the case studies question. Let's start the session. Okay. So this is class number 2. Always at Saturday we just do the case studies question. Number one question on the screen is that, see, ABC Bank granted a loan to XYZ Limited. So, ABC, that is a bank, okay, granted a loan to the XYZ. Is that okay? This is a company. And this is a bank that's granted loan to a company, okay? Took a mortgage on company's property, and company have given mortgage as a security. It means the company have given immovable property as a security. Due to the financial difficulties, XYZ Limited defaulted on loan repayment. ABC Bank, being secured creditor, initiate the action under SARFAESI Act. So class, we know that in SARFAESI Act, without intervention of the court, how bank and financial institution can take money that is given in the SARFAESI Act. Okay. So class, what is the first step ABC Bank should take under SARFAESI Act after XYZ Limited default? Number one is they can file a civil suit in court. Second, issue a 60-day demand notice under section 13 clause 2, sell the mortgage property immediately and hand over the case to the police. So class, tell me which of the following is the right answer under SARFAESI Act. Hanji class. Which of the following is the right answer? So class, we know that in SARFAESI Act there are two options. Option number one is giving borrower the notice, and option number two is regarding the ARC company. So in this one, the right answer is B. Issue 60 days demand notice under section 13 clause 2. Is that okay? Next question. A agree to sell land to B for rupees 40,000. Okay. A agree to sell land to B for rupees 40,000. Okay. Done. B pays A 4,000 as a deposit at the time of contract. It means B have paid 4,000, okay, to A, okay, at the time of contract. The amount to be fortified to A, it means amount will be given to A if B does not complete the sale within the specified period. It means B has deposited 4,000, okay, and the amount to be fortified to A, okay, if B does not complete the sale within specified period. In this case, B failed to complete the sale within the specified period, nor is ready and willing to complete the sale within the reasonable time after the expiry of that. Now tell me class, can A, the question is, can A rescind the contract? Rescind means end the contract. At the same time, retain the deposit. Retain means to hold. What is retain? To hold. Tell me the right answer. This is very good question. Can A rescind the contract at the same time retain the deposit? Retain is, that is, hold the deposit. So class, in this case, as you can see that, first of all, this particular case is basically that both party have to perform their performance. Exactly. A have to perform, B have to perform. Okay. Because A agree to sell. Agree to sell means that is the future sale. What is this? This is future sale. A agree to sell land B for rupees 40,000. B pays 4,000. It means B have done some portion. A have not done some. Okay. Now the B does not complete the sale. So class, in this case, first of all, the answer A rescind the contract. The answer is yes. At the same time, retain the deposit. The answer is yes. Okay. Now see the reason behind this. First of all, see the analysis. B failed to perform his promise. The security deposit can be fortified as per terms of the agreement. Fortified means to lose. A can rescind the contract, at the same time retain the deposit. Okay. The fact you people know. Now see the provision that is behind the question. Okay. So class, if the promises, what is this? If the promises are conditional and dependent, the performance of promise by one party depends on the prior performance of the promise by the other party. Is that okay? If the promise are conditional and dependent, okay, the performance of promise by one party depend upon the prior performance of the other. If such promises, if party who is bound to perform his first, it means in a contract, one party have to perform the promise first. So suppose if he is failed to perform, then he cannot claim performance from the other party. Exactly, because see, in any contract, one party must have to perform the contract. Moreover, the defaulting party becomes liable to pay the compensation to other for the loss suffered by other for the non-performing of the contract. Okay, so this is important one. So this is the concept regarding the performance of the promise. Is that okay? So that is easy one. Now, Mr. Ramaswamy of Chennai place a order with Mr. Shah, that is of Ahmedabad, supply of urad dal. Okay, supply of urad dal on 10/11/2006 at the contract 40 rupees per kg. It means at the time of contract, okay, at the time of contract, that is when the contract was done, the price of the urad dal was 40 rupees per kg. Okay, the order of supply of 10 tons within the month of time. It means Ramaswamy want 10 ton of, that is 1 ton is equal to 100 kg. 10 ton, that is 1000 kg. So Ramaswamy want 10 ton. Okay. Okay. Before 9/11/2006. It means that is the ultimate time in which Shah have to perform. Okay. Within that period, he have to perform. Shah have to perform. Now class, on 4/12, on 4/12/06, Mr. Shah wrote a letter to Ramaswamy stating the price of urad dal is 50 rupees per kg. It means Shah wrote a letter that the price of urad dal is 40 rupees per kg and he would not be able to supply as the original contract, because in the original contract it was 50 rupees 40 rupees per kg, but right now it is 50 rupees per kg. The price of urad dal rose up to 53 on 9. So in 9/12/2006, the price was 53 rupees per kg. Now class, advise Mr. Ramaswamy citing the legal position, because see, the contract was done on 10/11/2006. On that day, Shah is ready to supply the tons of urad dal at the rate of 40 rupees per kg, but he have to perform his contract, okay, within 9/12/2006. But Shah see the price, but Shah is, see that the price is, already gone up. So you have to tell me in that case that what will happen. what Mr. Ramaswamy can do. See class, this is the case studies question. The four options will come. The four option you can get when you see the concept. Okay, so tell me the right answer. So class, first of all, this is very good question. Now see the right answer. Because see, there is a one word that is breach of contract. There is a one word that is breach of contract. What is breach of contract? That is the end the terms of the contract. That is called the breach of contract. Mr. Shah, Mr. Ramaswamy have done the contract, but Mr. Shah not fulfilling the terms of the contract. So he is just done the breach of contract. So in that case, he have not performed any act. Mr. Shah have not performed any act. So before performance, he have just breached the contract. In between, suppose in between the contract, if a person breach the contract, that is called actual breach of contract. But before performance, if he is just, the breach of contract is there, so it is anticipatory breach of contract. So in that case, Mr. Shah have not performed the contract because he have to give 10 tons of urad dal, but he have not done anything. So this is called anticipatory breach of contract. Is that okay, class? Now see, Mr. Ramaswamy can repudiate the contract, okay, can claim the damages. He could wait till 9/12/2006 and claim the compensation. The one exception is there. Suppose if a government in the interim period between 4/12 or 9/12/2006 imposes a ban on the movement of commodity to rise the prices, it means suppose if government give an order that nobody will transfer urad dal between 4/12 and 9/12. So in that case, if government is imposing the order, so in that case, the contract will become what? The contract will become void. And Mr. Ramaswamy will not be able to recover any damages whatsoever. So this is very much important, class. Now, as you can see, anticipatory breach of contract occur when the promisor refuses altogether to perform his promise, signify his unwillingness even before the time of performance has arrived. Okay, for this, the promisee need not wait till the time stipulated in the contract for fulfillment of the promise by the promises is over. Okay, so this is exactly the provision, fact of the case, and the analysis. So you do not have to write these much, but at least understand the concept that the question is asking. Okay, next. It's a PQR hospital is there that recruit Dr. A on a contract basis for 3 months. Okay. Okay. The hospital management promises to pay Dr. A amount of 1 lakh if he tests positive for coronavirus. It means that is the health benefit that the hospital is giving if anyone just got coronavirus. Now tell me, class, identify the type of contract and highlight the rule enforcement. Also, what will happen if A does not contact with coronavirus? So this is a simple and a very good question. So class, in this case, first of all, what is this? This is a contingent contract. What is contingent contract? When a valid contract is depend upon the event, and that event is uncertain future event. Okay, valid contract that's depend upon the event. Okay, and that event is uncertain future event. Is that okay? So class, in this case also, the company have, the hospital have promises to pay a, okay, that's a valid contract. So when the hospital will pay a, when a got the coronavirus. Is that okay? But if A does not contact with coronavirus, the contract become void. Okay. In the instant case, the contract between hospital and A is a contingent contract because the promisor, that is a hospital, need to perform his obligation paying A amount of 1 lakh only if he contact coronavirus within 3 months. But Mr. A didn't contact with coronavirus, so that's why the contract will be void. So this is your contingent contract. See the definition. A contract to do and not to do something if some event collateral to such contract does and does not happen. So in simple way, I'm telling you, when the valid contract is dependent upon event, that is called contingent contract. Okay, that event should be uncertain future event. Mr. Murari owes payment 3 bill to Mr. Giridhar as on 31st March 2020. 12,120 due in May 2016, 5,650 due in August 2018, 9,680 due in May 2019. Now class, Mr. Murari made payment on 1st April 2020 without any notice how to appropriate them. So this is the hint that you have to found. He have given, Mr. Murari have given check of 9,680 and check of 15,000. So you have to identify that which provision of Indian Contract Act apply in this act. Very important question. So class, I'm telling you, in this case, it's a FIFO. What is FIFO? That is Clayton rule. And what is Clayton rule? That is appropriation of money. FIFO is first in, first out. Clayton rule is from 59, 60 and 61. So what is Clayton rule? It's talk about the appropriation of money. So if Murari have given 2 check, the first check is of, you can see here, of 15,000 and one check is 9,680. So appropriation of money means adjustment of the money. So this 9,680 will be adjust with this one and 15,000 will adjust with this and this one. So this is called appropriation of money. Section 59 talks about if the debtor indicate. 60 talks about if the creditor indicate and 61 talks about in the order of time. Okay, so that's all for this one. Now see, you can see the analysis. As one check was exactly the amount of bill drawn, it would be understood, even though not specifically appropriated by Mr. Murari, that it will be against the bill of exact amount. Hence, the check of 9,680 will be appropriated against the bill of 9,680, which was due in May 2019. Check of 15,000 can be appropriated against any lawful debt which is due even though the same time is debarred. Okay, so this is your Clayton rule. Okay, 59, 60, 61 talk about the Clayton rule. Okay class, so that's all for today's. So I hope so you people like this session, and do not forget to see all the sessions of case studies question at every Saturday or Sunday. Okay, thank you so much class.